State of Michigan versus Christopher Moore.
Good morning, Your Honor. Jessica David for the people, P86743.
Well, Your Honor, Jeffrey Defiant on behalf of Mr. Moore, who is present by Zoom. Judge, this is time and date set by the court for an in-person hearing relative to Mr. Moore for a proposed bond violation. Addressing the in-person issue, Judge, Mr. Moore played me a phone message that came from the court that should have been, I think the court just called the wrong number and left a message on his number indicating a hearing, but it was directed towards Ms. Butcher. And so he did not have knowledge that he was supposed to be here in person. Number two, I would ask the court, after talking to Mr. Moore, request the court, based upon the landlord-tenant matter that was before the court, I think last week or the week before, would request the court recuse itself and set this matter for hearing before Judge Slavin tomorrow morning. We would be prepared to address the violations at that time. And Mr. Moore will be here in person.
Okay, well, I want to address that. We can set this for the morning. I don't believe that that's grounds for recusal on this case. Mr. Moore was present. There was a landlord-tenant case. His conduct at that landlord-tenant case occurred in my presence in open court on Zoom and on YouTube. And I don't know that anytime someone in a case behaves poorly in a courtroom that I should have to recuse myself. I don't know that that's the appropriate remedy. I certainly believe I can be fair and impartial on this case. I certainly have concerns with the allegations of the bond violations, but at this point in time, I'm not recusing myself from this case. I don't think it's necessary or appropriate under the judicial canon.
What happens when a man accused of domestic violence decides he's the real asterisk victim? When he breaks bond, skips court, threatens the courthouse, and gets caught on camera, breaking into the victim's house with a gun in hand. Welcome to the courtroom disaster known as Christopher Moore. What began as a basic domestic violence case quickly Moore fumbles through legal proceedings, fires his attorney mid-hearing, and tries to outsmart the judge badly. But stick around, because we've got wild surveillance footage, failed Zoom hearings, emotional court outbursts, and one of the most epic case self-destructs we've seen this year. And yes, he cried. Let's get into it.
Set for tomorrow morning. I'm going to be here. Mr. Moore will be here.
Okay. It should be in person.
He will be in person.
Okay. Miss Maudlin, I don't know what our day looks like. What's that?
You have landlord-tenant.
I have landlord-tenant. It ends around 10. My second batch is at 10:30.
I'm here all day, Judge, so whatever.
So Miss Maudlin, maybe we'll just do it around 11:30.
I think there was another case.
All right, let's just make sure that there's something. I don't know what all we have tomorrow. 11 a.m. tomorrow. Well, Miss Davidova was courteous enough to join us today from the prosecutor's office. This is not her docket. I'm guessing she's got another place to be tomorrow.
I do have court in the morning, Your Honor, tomorrow, but I can make like 11:30 work. I just circuit court sometimes is backed up.
I get it. Is that okay?
That's fine, Judge.
All right, Miss Davidova, you're free to appear via Zoom. Miss Butcher, you're to appear via Zoom. Mr. Moore, you're to appear in person.
Your Honor, before we go,
Sorry, go ahead.
before we go for the day, can the court inquire where Mr. Moore is presently?
My understanding is Mr. Moore checked in and told one of the clerks that he was out of state right now.
Mr. Moore is not commenting, Judge. He has a right to not say anything.
He's exercising his right to remain silent, Miss Davidova.
All right. Thank you, Your Honor.
And Mr. Moore.
The classic, I didn't know I had to be there excuse, courtesy of a wrong voicemail. Except, Mr. Moore was very clearly told to appear in person. And when the judge doesn't recuse herself because he acted out in a landlord-tenant hearing, Moore's team tries to pivot. But here's the thing. If throwing a tantrum during your rent dispute was a get-out-of-court free card, half of TikTok would be untouchable. Moore's defense is already unraveling, and we're only 4 minutes into this hearing. Buckle up, Asterisk.
In here, this is 241136 SM, the People versus Christopher Moore.
Good morning, Your Honor. Jessica Davidoff for the People, P86743.
Morning, Your Honor. Jeffrey Fant on behalf of Mr. Moore. Judge, Mr. Moore has not appeared. I did try to call him. My call went straight to voicemail. I did check with security downstairs. He has not come into the building to their knowledge. I do not have an explanation for his non-appearance.
All right, and I would just note for the record, Mr. Moore was here yesterday and we set this for today so he could appear in person. He was advised at the time and the date on the record. He indicated he would be present. He's failed to appear. An immediate bench warrant will issue for his arrest. So he's a flight risk. He certainly, at least appears to be, based on the allegations, a danger to Miss Butcher. So he will have an immediate bench warrant for his arrest.
Thank you.
Okay.
Thank you. And Your Honor, for the record, may I note Ms. Butcher is present today on Zoom.
Thank you. I recognize that and I noted it on the file. So, okay, we are all set. And Ms. Butcher, I'm sure that Ms. Davidoff is advised you on what to do in the event there's any contact. And once he is located or picked up or turns himself in, the court will set.
And gentlemen, you had one job asterisk after being told on the record to appear in person at 11 a.m. Moore goes to the court like a bad Tinder date. The judge, not amused. The prosecutor, already filing a warrant. And us, watching this man dig his legal grave in real time. You think someone staring down felony charges might want to show up, but not our guy. So here's a question for you. Do you think Moore's just reckless, or does he genuinely believe he's untouchable?
Probably gonna have to call and get him yet another attorney.
Can you handle the arraignment today?
Yeah, I can I'll do the arraignment, yes.
All right. I mean, he needs to be arraigned, and so, and then we'll let them know that we need yet another attorney.
Yes. I tried to explain to the client that I would schedule it with him so that we could talk at length, and that really upset him. I did explain that, I needed to go to the courtroom at this point and then speak with him on Zoom at a later date, but he wants another lawyer.
Okay, so let me call these the new one first. This is 241976, People versus Christopher Moore. So Mr. Moore, initially you had an attorney that was appointed through NDS, and they had the attorney they appointed was not I don't want to say qualified, but she didn't meet the standards under the Michigan Indigent Defense Commission's to handle a case of this nature. So she was removed from the case because she can't be on that list. Then Miss Watt was nice enough, kind enough today. She was called to stand in on this or come into the case forthwith so that you could have your court date. So I just want you to know what happened today. So now we have Miss Watt here. It was scheduled at 1:15. All we're handling today is the arraignment. So you're being arraigned on your new case. And I've known Miss Watt for many years. She is a very good defense attorney. And obviously those are decisions you can make, at least for the moment. But I am going to proceed with the arraignment. And then if you want different counsel, Miss Watt, it sounds like there's a breakdown.
Yes.
Okay. So, Mr. Moore, on this case, Ms. Watt, can I get your appearance for purposes of arraignment?
Yes.
If she's going to be
Coral Watt, appearing on behalf of Christopher Moore, P41508.
Okay. So, Mr. Moore, we can get you a new attorney if you want a new attorney, but I'm arraigning you on these charges.
Your
Okay,
Honor,
well,
we stand here to make the formal reading of the warrant on the charges, Your Honor.
Okay. So, Mr. Moore, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during.
This is where things take a dark turn. Surveillance footage, a masked intruder, a gun pointed at the mother of his child, and he adjusted the cameras to hide it. We're no longer talking about bond violations. This is criminal escalation. And to make it worse, he was staying across the street from the victim. The prosecutor is laying it out piece by piece, and the courtroom goes from annoyed to alarmed. These aren't just allegations. There's video. Remember that word, because it'll come back to haunt him home.
Any future questioning and any future court hearing. If you can't afford an attorney, one will be appointed to represent you, as Ms. Choate was, now Ms. Watt was. And it's my understanding now that, Mr. Moore, you want to fire Ms. Watt?
Correction. I have witnesses in here. She was not listening to what I was finishing trying to say. I had to stop because somebody else, as you can see, there's other court proceedings going on here with several other judges, several other inmates. Got a basketball gym that we're holding court next to. I have cancer. I just had a seizure while I was in custody at Taylor PD when I was picked up. I was sat in the hospital for 4 days. I was trying to tell her, she's trying to present an argument, and I'm trying to get her to understand, but then she's saying that she.
What started as a $500 bond and a simple DV charge has now become a $250 000 cash bond with 7 felony charges. This is like turning a speeding ticket into grand theft auto on purpose. But let's appreciate the sheer irony. This man cried in court, claimed he was being set up, and begged for sympathy, all while knowing he'd been caught on multiple cameras committing multiple felonies. That takes either guts or a stunning lack of brain cells.
More. Listen, Miss Watt was appointed to your case 2 or 3 hours ago. So of course she doesn't have discovery. She was just appointed, and that's not her fault at all.
It's clearly not my fault, ma'am. I was asked a question and I was trying to
respond. You. All right, Mr. Moore.
All I was simply asking, just let me know when I can speak, please. So we're not.
All right. Well, you have 2 dates within the next 21 days. The first is your probable cause conference, which is set for September 4th of 2024. Following that, you will have a preliminary exam. You are to appear in person at that hearing, and that is September 9th of 2024. And we will get this back down and have another attorney appointed to represent you. Mr. Moore, are you telling me that there's been a breakdown between you and Ms. Watt that you believe affects her ability to represent you?
I didn't say anything. She said that she was going to go back into the courtroom. This is what she said. I didn't even say anything. She said she's going back in the courtroom. Oh, this ain't going to work. I was like, what's not going to work?
I don't speak like that, first of all, Your Honor.
All right. Well, let me ask you, Ms. Watt, instead of Mr. Moore, Ms. Watt, has there been a material breakdown where you can't represent him?
Yes, Your Honor.
All right. So you're being removed from the case.
Thank you, Your Honor.
But I'm setting bond on this case. Now, he currently has a $250,000 cash surety bond on his other home invasion case. This one is certainly even more concerning. So, because now he's gone to home invasion first.
Home invasion? What are you talking about?
Moore just broke a new record, firing his second attorney within hours of the first one being dismissed. Why? Because she had to go to court and didn't immediately download his discovery packet. Let that sink in. She was assigned just a few hours earlier, agreed to help him out, and he's throwing her under the bus mid-hearing. It's almost like Moore's biggest problem is Moore. But hey, at least the judge knows exactly how to handle this circuit.
Listen. You know what, Ms. Watt, I don't want there to be any confusion or anyone to say nobody did their job. So here we go. The allegations are that the date of occurrence is August 12, 2024. And the witnesses state that on the date at that location, the defendant, contrary to law, committed count 1, home invasion, did break and enter or did enter without permission a dwelling with the intent to commit an assault therein, and while entering, present in or exiting the dwelling. Shamani Butcher was lawfully
Shamani.
present therein and or was armed with a gun, a dangerous weapon, contrary to MCL 750-110A, parent 2. That is a felony punishable by up to 20 years in prison and a fine and or $5,000 fine. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 2 is weapons felony firearm. The allegation is that you did carry or have in your possession a firearm, to wit, a handgun, at the time you committed or attempted to commit a felony, home invasion first degree, contrary to 750-227B. That is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 3 is weapons, firearms, possession by prohibited person. The allegation is you did possess and or use a firearm when ineligible to do so because he or she had been convicted of assault with intent to do great bodily harm, less than murder, and or uttering and publishing an offense punishable by.
And here it is, the moment he tries to play dumb. The judge begins reading the exact charges, date, time, location, video evidence, and Moore responds with, "What are you talking about? Sir, it's you, on camera, at 2 a.m., in a mask,